Hello, everyone. Thank you for joining us. Welcome to Know Your Employment Rights Recruitment. My name is Khadija Guillaume. I will be your host today. I am also the project coordinator for employment equity and career promotion with employers at Connecture Canada. Today, we have a lot to discuss surrounding the importance of employment rights, human rights during the recruitment stage of the hiring process, how the Ontario Human Rights Code protects you at that stage, the red flags and green flags to look for during an interview, and steps to take before signing legal documents and contracts. Additionally, we will be looking at the difference between your human rights and the employment rights, and lastly, the barriers during the recruitment process for racialized individuals. Joining me today are four incredible and knowledgeable Canadian employment lawyers and human rights specialists who are here to have these discussions with me, to inform you and share their knowledge and expertise on the topics, and above else, to inform you on what you should know about your rights in the hiring process. Before we get into anything, I would like to first acknowledge the land that we are meeting on is the traditional territory of the many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, and the Haudenosaunee and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. We also acknowledge that Toronto is covered by the Treaty 13 with the Mississaugas of the Credit. Folks, I'm excited to share with you our panel. First, we have Paula Kraus joining us from British Columbia. Paula is an employment and a human rights lawyer and co-founder of Porta Law. Her strengths as a lawyer come from her ability to empathize and communicate. Although she approaches problems with a positive mindset and thoughtful advocacy skills, and works best with clients who value collaboration through their legal matters, human rights advocacy holds a special place in her heart. Next, we have Andrew Goldberg from Ontario. Andrew is an employment lawyer and partner with Sanford Tumarkin, with a diverse background in labor and employment and a history of past work experience in the investment management and CPG sectors. Andrew provides legal advice to employees and employers in all aspects of employment and human rights laws across Ontario and Alberta. Andrew is dedicated to resolving complex employment disputes for his clients in an efficient and pragmatic manner. In doing so, he is committed to utilizing his effective advocacy and negotiation skills to provide his clients with timely and favorable resolutions. Next, we have Colene Roache, an experienced senior talent acquisition consultant with the demonstrated history of working with utilities industry. She is skilled in HR consulting, coaching, executive search, team building, and technical recruiting. Lastly, Colleen possesses strong talent acquisition professionalism and is a people leader. And finally, we have Nita Chhinzer. Dr. Nita Chhinzer is an associate professor of human resources at the Department of Management at University of Guelph. Her research is concentrated on strategic human resources management with a strong focus on downsizing practices, procedures, and ethics. She completed her PhD in management from McMaster University in 2006, focusing on HR. Accordingly, her research area is largely focused on downsizing activities, consequences, and decision-making. Thank you all for joining me today. It's so great to have you all here, where we'll get to listen to you, hear you share your knowledge, your tips and solutions on today's topics of discussion. How are you all today? Good, good, yep. Thumbs up, some smiles. Okay, good. That's good. Folks in the attendees that we have today, I would just like to invite you personally to take advantage of today's discussion by sharing your questions. If you have any questions, feel free to use the Q&A option at the bottom of your screen, or as well as the chat. I believe there is a chat option there, so feel free to take advantage of asking questions. Our panelists will be more than happy to answer them. Not me. them. They're the ones with the knowledge. I'm just here to listen and host. All right, so I'd like to kick things off first by talking a bit more about your career choices. You all have expertise in employment law, in human resources, and in human rights. I'm curious to know what exactly motivated you, or what led to your decision to pursue a career and commitment in employment law or in human rights and human resources. Nita, may I please start with you?
Sorry, I had to get off mute. Okay, so if I'll go into a time machine, then it was after my MBA, 1999, I was working for Nortel Networks, which was Canada's darling, Canada's biggest employer. And our stocks were at 120 and we were going upwards. And then the bubble burst. And in 2000, we went through round after round after round of layoffs. And eventually Nortel Networks became penny stock. And every time the round of layoffs went off, I could see the damage it was doing to the organization. You could see the reactions on an individual level, but the MBA part of me understood the need for layoffs. I understand that you don't need to always keep the same number of people. Sometimes you have to cut them. But then the human in me was like, there's got to be a better way to do this. So that's what prompted me eventually to put my hand up and be like, when's my turn for the layoff? So I could go back and do my PhD and look at it from both the employer perspective and the employee perspective. We've got to balance both needs, and that's what I bring to the table.
Excellent, excellent. I appreciate your backstory. I think it's very insightful. Paula, may I start when I continue with you?
Yeah, for me, I can sort of talk about my young idealistic ways before I started my career and why I wanted to be a lawyer. But why I went into employment law eventually is not that interesting. I don't know that it was necessarily a calling. It was just from what I had already practiced for a few years, in what interested me the most and what I like myself, my body, my mind, and my soul could handle. The legal industry is very tough. Being a litigator is very tough on you. And I found that employment law was something that I was good at, that I enjoyed. And that wasn't going to run me down in a way that I thought other kinds of law would. So that's why I'm here today.
Oh, that's not uninteresting at all. That's actually very, very uplifting. Thank you for sharing. Andrew.
Sure. I kind of had an interesting career path. I had zero intentions of ever being a lawyer. I originally went to school for business management and finance, and it was a very math-driven program. And I was pretty good at math. And for a lawyer, I'd say I'm exceptionally good at math, which is a very low bar. But I realized my skills were really with people more than numbers. I felt I had a relative, leg up versus other people as it relates to just connecting with individuals and advocating orally or in writing. So after I was done my business degree and worked in finance for a while, I just did a 180 and went back to school, which was a tough thing to do at that time. And I had no idea what kind of law I would do. Like Paula, litigation is something that really interested me. And employment law is an interesting area of law because it's relevant to everybody, right? Like it's relevant to your friends, your family, and everyone you know. If you're a corporate securities lawyer or a corporate tax lawyer, 95% of people you interact with on a daily basis, they have no idea. It's just so irrelevant to them. They couldn't care less, and there's no applicability in their lives. So employment law, on the other hand, it's something that everyone, I'm sure the rest of the panel can attest to this. It's just something that everyone's interested in. So it's kind of unique from that perspective, and I find that that's drawn me to it quite a bit. And through kind of an organic process of finding my way, I ended up where I am today.
And this is someone who said that they never imagined themselves being an employment lawyer, and here we are today.
Exactly.
The tables have turned. And Colleen, yes, we'll end off with you.
Okay. Well, like Andrew, I didn't think I would ever get into human resources. I wanted to become a flight attendant. And my first part-time job, my manager asked me to interview with her. We were looking for part-time staff, and she's like, "You're actually pretty good at this." So she had me create a couple questions to ask potential candidates, and my mom was happy about that because she didn't want me flying all over the world. So I decided to get into human resources, and also because of my passion of people and my passion of making people become employed was a passion of mine since I was in high school and college. So that's why I got into human resources.
Okay, thank you. Thank you all for sharing. I do appreciate it. Thank you so much. Now I would like to get into the topic of human rights versus employment rights. Speaking of which, in Ontario, actually in both Ontario and British Columbia, we have what's called the Human Rights Code. Ontario Human Rights Code and British Columbia Human Rights Code. And this code is put in place to essentially to protect us against forms of discrimination in different social areas, such as services, accommodations, like housing, and important of all, employment. On the topic of employment, I think it's important that we discuss the difference between the two. A lot of people seem to think that it's the same, but they each have their own sectors, their own characteristics. And then I would also like to talk about how the role of human rights plays in employment law, especially in the hiring process. Paula, if you may, and everyone else, feel free to join in. But Paula, I'd like to start with you, and I'd like to start off and ask what defines human rights and how does it play a role in the context of employment? Like I said, everyone is free to jump in afterwards.
Yeah, I'm happy to start off the conversation. So in Canada, we have decided as a society that there are certain parts of ourselves as humans that cannot be held against us, at least in in certain important parts of life. So every jurisdiction, meaning every province and territory, and then Canada as a whole, has a law, a written law, that talks about those parts of us, those characteristics that can't be held against us. So those laws in every jurisdiction are a little bit different, but the principles behind them are the same. And so it's called the Human Rights Code. In some jurisdictions, it's called the Human Rights Act. But more or less, they all protect us in certain parts of life, i.e. what you've already talked about, and that's housing, tenancy, services, and employment. So today we'll talk about employment, and the reason that where there are certain areas of life that are sort of specified in these human rights codes is because the government isn't policing what me and my friend are talking about over wine in my own apartment, right? But it's important that my landlord doesn't discriminate against me, right? So we've chosen a few areas of life that are extra sensitive, I guess I would say. And so we're talking about employment today, and these sort of characteristics that can't be held against you, we call them inherent characteristics. They are parts about human beings that sort of they cannot be detached from our identity, from ourselves, from how we define ourselves as individuals and human beings. So they're inherent to who you are. A few examples are race, ethnicity, language, religion, creed, sexuality, sexual orientation, sexual expression, or gender expression, gender identity. So there are most of these, if not all of these, laws in each of these in all of our jurisdictions spell out. They tell us a list of characteristics that can't be used against us. Means we can't be judged negatively based on these characteristics. So human rights are rights that are tied to inherent characteristics that we as human beings, as individuals have. And those human rights exist not in all parts of private life, but in certain parts of private life, including employment.
Excellent. Thank you so much. That was very detailed and very, very informative. And it's important that we know these things, because a lot of the characteristics, tend to go over our heads, or we just aren't aware of it. Would anyone else like to provide feedback and comments?
Sure, I don't mind supplementing that a bit. I echo very much what Paula said. I think one other thing to keep in mind as it relates to pursuing human rights related issues is you don't have to do so through a court, right? So if you have a strictly employment related issue, if it's a wrongful termination or a constructive dismissal or a breach of contract or something like that, then your recourse is to sue through our the court systems. And typically you need a lawyer to do so. You can self-represent, but it's extremely difficult and not advisable. But when it comes to human rights related issues, if you feel you're discriminated against based on one of the protected grounds that Paula went through, then you can actually go through a tribunal process, like through the human rights tribunals. And they're actually designed so that people who aren't lawyers can do it on their own initiative. You can do it on your own and file the complaint, and they kind of help you along the process, which is much looser than the rigid court system. So it's just another way that the provinces and Canada as well federally have kind of emphasized the need for people who are in a vulnerable position to have recourse without having to incur legal fees with a lawyer or anything like that. Now, oftentimes, employment issues and human rights issues, they go hand in hand, right? So I know that you preface this by saying, employment law versus kind of human rights law, but they're really woven together in a lot of ways. And, oftentimes, you'll be fired for what you perceive to be discriminatory reasons, right? And in that happening, you might want to pursue, an outstanding bonus and your severance and things like that, but also human rights damages. So you kind of have to bring everything together. And oftentimes those issues are going to come up, side by side, and they'll be kind of integrated as a whole. And that's what we see all the time, right? Like that's usually why people come to us, because they just feel, even though they don't know the law, they just feel like there's something wrong with what happened. And sometimes they have legal ground to do something and sometimes they don't. But oftentimes if it's just like a severance issue, if someone feels that they didn't get enough severance, they may not speak to a lawyer just because they simply just don't know enough about severance to think that they should or shouldn't. But when someone's fired and they feel there's like a discriminatory undertone, it usually prompts them to say, okay, something's wrong here. What can we do about it? And, that's what my practice really is all about, is trying to assist those people in the pursuit for, some form of justice one way or another.
No, that's excellent. That's excellent. Speaking, Andrew, you mentioned earlier about how human rights and employment rights kind of go hand in hand with each other. But on that same topic, my next question then is, and this is primarily for Nita and Paula, but everyone else, again, you're more than welcome to join in. But on that same topic, in both BC and Ontario, I discovered that mask and proof of vaccination are required for any and all indoor public spaces. But to my knowledge, most employers have not mandated that in their work environment, although some are choosing to do so. Nowadays, people think that a company or organization implementing a mask or vaccine policy are infringing on their human rights. Individuals see it as a violation of their human rights. Is it though? Is it a violation of human rights? And the Human Rights Code, should a company or organization make it mandatory for their employees to be fully vaccinated, or at least have to wear a mask?
Try. Are you able to hear me okay? I know sometimes my sound cuts out. Great.
Nope,
Okay.
nope, you're perfect.
Great. So an organization has to operate inside the framework and established rules and regulations of the greater society. So when the mask mandates are in place from our federal government, our provincial government, our local government, the organization does not have the right to supersede that. So employers must then abide by the legislation, and that involves discussion about reduced capacity. They don't have the right to exceed the capacity limits. They don't have the right to say, no, you don't wear a mask. So most employers, in fact, are abiding by that. And if they don't abide by that, they're violating the mandate that's there. And employees have the right to then put in, claims around those violations. But when it comes to the concept of whether it's a violation of rights to ask people to wear a mask or get a vaccine, the question comes down to what right do people think that they are being violated against? And when I'm speaking often to student groups or executives, I have to remind them that the rights are very pragmatic, that these classifications in certain jurisdictions qualify as something that's a protected right. You cannot be discriminated against it. But that's not an all-encompassing. So an example I might give is perhaps I have a negative feeling towards anyone who's wearing a purple sweater. And I discriminate against someone because they're wearing a purple sweater. And they say you violated my right. Well, the choice of the color of your sweater is not a protected clause in human rights legislation. Therefore, yes, what I did was unethical, maybe it was immoral, but it was not a violation of the established rights. So when it comes down to if a vaccine or a mask mandate violates people's rights, we have to think about what that right is. And the right that we're hearing mostly is about, religion, because some people do have religious rights. And what I've been hearing from employers is they're pushing back a little bit and saying, okay, if it's against your religion to get an injection of this kind, then can you show me evidence that you have gotten no other injections prior to? We've got a vaccine mandate for kids in schools, things like, measles, mumps, and rubella. And those are because of the greater good to the broader society. So the organization has to remember it operates within that broad area, but employees have to remember what right do you think was actually violated? And you can't just say, in this one case, my right was violated, but I let that be violated 12 other times before with no problems. So we have to look for consistency there. Does that help clarify, or does it confuse the situation even more?
No, not at all. Not at all. That's actually very important to discuss. You mentioning previous situations where said violation was allowed, but in this particular work environment, let's say, it's not permissible. So I do agree, if an individual is going to say, well, no, you violated my rights here, but then you look back and you see that same violation was allowed, it's kind of questionable. Yeah, no, I agree, absolutely. Not confusing at all.
Definitely,
So
thank you.
I think what I'll do is sort of tie, because we can talk for hours and hours about vaccines and masks, right? This is not the topic of this webinar, but very simple in BC, and maybe Andrew can pipe in about what's happened in Ontario, but in BC, the Human Rights Tribunal has said flat out, no, mask mandates are not a violation of human rights. It's that simple. It's done. There are a couple of decisions that have said that, because somebody's desire to not wear a mask doesn't fall under religious belief, under sexuality, under gender expression, under religion, et cetera, et cetera. There are, just like in any situation, when a person has a bona fide, a real disability, for example, or religious belief, then those things have to be accommodated, right? But a mask mandate in and of itself, it is not discriminatory. We have to remember discrimination as a general concept isn't unlawful. Anita had a really good example. You know, I actually use like purple hair in my examples and not purple shirt. You know, I as an employer might say, no, you cannot wear a purple shirt to work, right? And that's discrimination. I'm discriminating against, you know, my workers who like to wear purple shirts. And yet that is a lawful form of discrimination, right? Really what human rights protect is when that discrimination is related to one of those inherent characteristics.
Mm-hmm. Boy, it'll be very awkward if there was attendees there wearing purple shirts right now.
Sorry guys, I really like the color purple. It's just
purple is a lovely color, actually. Yes. Moving into now, I want to. So you are right. We could have hours and hours conversations about COVID and mask policies and vaccine policies as well. But now I kind of want to. Actually, sorry. Before I continue, Colleen, Andrew, did you want to pitch in on this topic? I do not mean to ignore you. I am not, I promise.
No, I think they did a good job at summarizing like the current state of things. It's similar in Ontario. I mean, a mask requirement, it's difficult too, because at times you're balancing, there's different legislation that impacts the situation, right? So on one hand, there's human rights legislation. And on the other hand, there's health and safety legislation. So employers are, you know, they have obligations to ensure a safe workplace, you know, free of, you know, undue risk in terms of your health and things of that nature. So it's a big balancing act, because on one hand, employers have to make sure people aren't discriminated against, but on the other hand, they have to make sure that it's a safe and healthy workplace. And, you know, something like masks, for example, I don't think there's much dispute that they're effective in you know, preventing the transmission of COVID, especially depending on the kind of mask. And another thing to keep in mind as well is, you know, if the government mandates certain requirements, so for example, if the government says, okay, in grocery stores, you have to wear masks, you know, and wherever you're in the airport, you have to wear masks. If you're the owner of a grocery store, you're not making that decision anymore to force your employees to wear masks. It's something that's been kind of thrust on you through government order, at which point, you know, you'll kind of be immune to repercussion anyway, because you're just kind of doing as you're told. So there's so many moving parts. And as the you know, was said earlier, we could talk about this all day, but I think if the attendees have kind of any specific questions on that point, I'm sure we'd be happy to address them.
Of course. Colleen? Oh, Colleen, you're on mute. There you go.
I'm gonna mute myself. I totally agree with the panel. We have a fully vax policy at our workplace. And in regards to, I agree, if you are traveling on an airplane or if you're in a grocery store, it is mandatory that you have to wear a mask. So in Ontario, I think that, you know, if any of the attendees have further questions on that, be happy to answer. But in regards to, you know, with the panel, I agree with everything that they've said.
I do too. It was all very informative. Thank you so much, everyone. Now I would like to kind of divert into talking about the rights throughout the hiring process. Colleen and Nita, if you may, would you mind sharing with us some red flags that you see come up a lot by an interviewer that a candidate should watch out for, whether it's, for example, like certain questions that they shouldn't be asking you from a legal standpoint, from a human rights standpoint as well. Would you mind sharing some red flags and solutions that candidates should watch out for that have been done by interviewers?
Paula, would you like to start?
Go ahead, Nita.
Colleen?
You go ahead, Nita. You can go ahead first.
All right. So we have to remember a lot of interviewers haven't been indoctrinated or trained in any way on employment law or HR. So oftentimes they may ask questions that are really sincerely not meant to be discriminatory, but they are. So they might ask you things like, what is your family situation? Are you a dual income family? Do you have children at home that maybe they're trying to look at whether or not you're going to be able to come into work, or whether your work hours need to be modified? And they're actually trying to figure out, how this applies to their world of work. But those are not questions that they're allowed to ask, because that falls under family status. So they are allowed to ask you questions such as, are you able to attend work for the hours that are required? As opposed to saying, do you need to do a pickup of a kid? Because that gets into family status. When you put in that kind of a situation, it's a great idea to say, what is the correlation of, whether I have children with the nature of the job or the job requirements. So it's fully a comfortable situation to ask back to someone who's interviewing and say, I'm just not sure I'm tying the link between, say my family status and the nature of the job. Like, how is this relevant to the job? And they may in fact say, oh, well, we were just wondering if you were eligible to work the hours of work or if you needed some modifications. So at that point, at least we can begin to assess what's going on. The places we also see this is innocent conversations. Like maybe you've got a history where you went to school abroad and somebody asks you a simple question like, how long have you been in Canada? Well, that again can be an interpretation of, citizenship or immigration status. So you want to be careful there again and say, maybe you want to give a vague response back. Maybe you want to ask in that case, what it is that they're looking for. Are they thinking about what skills are transferable? Because then you can get to the crux of what the person's trying to ask. Now, I, as a management person, am believing that these people are not, most people are not intentionally discriminating against us. And so with that frame of mind, I think it's good to push back. At this point, I'll open it up to my colleagues as well.
Some of the things that I see or have heard in regards to interviewers that are not trained is maybe asking, where do you live? A lot of candidates look at this as being some form of discrimination. If I live in a neighborhood that's, maybe West End or East End of the city, the employer might look it up and think, what, I'm not sure if I want to employ someone that lives in that particular area. This is why you'll see a lot of candidates remove their addresses from their resumes. So that's been something that's been normal over the I would say the past 5 or 6 years, where candidates will not include their addresses based on the feeling that they may be discriminated in if they live in a certain area of the city. If an employer asks you where you live, sometimes they may want to ask you because based on determining if you live, let's say, in the city of Markham, but yet still you're traveling to downtown Toronto, they want to figure out whether or not you can get to work. So the easiest question is to say, I have reliable transportation. I know how, in regards to, I'm flexible. I can find my way to work. I depend on transit or I drive. You can avoid, actually saying where you actually live.
Okay. My follow-up question to you both then would be, how should a candidate respond when an interviewer asks them questions that, potentially violate or come off as discriminatory questions, such as, how's your physical health? What is your marital status? Where do you live? Like Colleen said, or even, do you plan on having kids anytime soon? How should a candidate politely respond to such a question?
Yeah, so my recommendation stands as it was before, which is just say, I'm sorry, I don't see the link with this to work, to try to dig at what the purpose is. And that's because, like I said, I'm naively assuming that most employers don't intend to discriminate, but we do have situations where employers intend to discriminate. We have situations where they don't hire women of a certain age because it's perceived that they'll go on mat leave soon. We have situations where they don't hire foreign trained professionals because of misassumptions or misalignments regarding their education level or their experience level. So in some cases, you may ask, what is the correlation to the job? And you get some very mixed message back, in which case you begin to interpret that this person is actually beginning to violate or discriminate against you based on a dispositional demographic characteristic, a protected one. And in that case, you've got a couple of options. My options I recommend to students and the executives that I coach is, one option is to say, is this even the kind of employer I want to be with? Do I want to be with an employer who's going to be making those kinds of judgment calls, who's going to be, we have people make comments about someone's weight, an interviewer's weight, an interviewee's weight. And we're talking about like just physical aspects. You don't want to work for an employer who's going to be that derogatory and discriminatory. And then think about if you want to come back and escalate it up through the employment standard, through the Human Rights Tribunal, and take the next steps if that is something that you felt really violated against.
I agree. Absolutely. Absolutely. All right. So my next question, again, on the same topic of discrimination in the hiring process and the right. Andrew and Paula, I remember doing my research, learning about the term Bonafide occupational requirements. In school, I remember reading about it, and it said something along the lines of how those could be considered a loophole because in employment law, the Bonafide occupational requirements allow employees to be specific with what qualities they are looking for in a candidate. But if we take it out of context, it could be labeled as discrimination. For example, even here in Ontario, we have the LCBO, when one of their requirements states that you have to be 18 years of age or older because it is by law to be of that age to handle or sell alcohol, not so much consume. But my question to you for you then is, are there other cases where certain discriminatory sounding job requirements may be permissible?
Yeah, and I would caution using the word loophole because, when we talk about a bona fide requirement, bona fide means sort of in good faith, right? So an employer may have real reasons to be looking for someone who is, female identifying, or who, is physically able to lift a certain amount of weight, right? Who speaks a specific language, right? So, these aren't loopholes. These are situations in which discrimination is justified, right? For a good reason. And so I won't necessarily go into, the specific legal test of what kind of what's bona fide and what's not, but generally speaking, if an employer has a requirement for a job position that is on its face discriminatory, it can still be justified if that requirement is, rationally linked to the job, right? And if it's been put in place, in good faith, right? So there's lots of different examples. One example is sort of a very, I would say, like popular, famous example here in BC, in the downtown east side. There are all sorts of different crisis centers, and there are centers that are focused on there are women's shelters and women's helplines, women's abuse helplines. And, an example is a requirement in one of these centers. They only hire female or female identifying candidates. And, that situation was escalated into the tribunals, and the tribunal found, in this specific situation, there is evidence. There is, evidence that, women are going to be, are benefited from having people at this center also identifying as women, because they are, for the most part, leaving a situation where their sex or gender is being is sort of at issue in terms of their abuse. So, or the reason why they're being victimized. And so, what that sort of example shows you is that there has to be, actual evidence. There has to be a real reason why an employer is putting in a rule about your sex or your gender or your physical ability or disability into a job requirement. So it does happen. It's not very common, I would say. In specific industries, perhaps it's more common to have these Bonafide requirements for a job position. But I think as an employee, as a candidate who's looking for a job, practically speaking, when you see these kinds of requirements on the job posting or are asked about them in an interview, I think you have to stop and think, okay, does this sound like, if this sounds weird to me, if I've got a gut feeling about this, let me take a step back and ask the employer, ask the organization, oh, how is this related to the job? And oftentimes you'll get a good answer, and sometimes if you don't, then I think you should take the recommendations that sort of Nita and Colleen are giving about how to respond.
Absolutely, absolutely, I agree. Andrew?
Yeah, I mean, I think that's just the simplest way to look at it, is there are just some jobs that inherently have certain requirements that are discriminatory by nature, but they're just unavoidable, right? Like, I think that's the real thrust of it. An example, and this might not be the case, who knows, technology. So as technology continues to advance as well, there's going to be less and less kind of avenues for employers to argue anything is like really necessary, because things are so adaptable. I mean, I've seen some pretty remarkable people do some jobs you never expect them to be able to do because of maybe a physical disability or something. But it might seem like a silly example, but imagine you were hiring a pilot, and someone comes for an interview and that person's blind, and that's a disability, they're blind. But if there isn't technology out there that would enable that person to fly safely, while it's discriminatory to not hire them in essence because they are blind, they can't possibly fly a plane in a safe manner. They can't do that job. And once again, that's just a situation where they're balancing safety of the people on the plane and everyone else, and with that person's disability. Now, who knows, like maybe there, as like I said, as technology develops, there could easily be some kind of workaround for that scenario. It's just an example, but it's just the idea that just because, and Paula had an example earlier about like weight requirements, right? So, if your job inherently requires you to lift a certain amount of weight, and there's no way to accommodate, someone's inability to lift that weight, then so be it. Like there's nothing an employer can do. Now, like employers have to be careful about how they kind of make that determination. I think, what makes the most sense is in situations like that, employers should provide an opportunity to do kind of like a test, like some performance test, to do the very similar tasks that you'd be expected to do as part of the job. So you're not really like asking about certain disabilities in particular and like trying to suss out all this information. You're really just trying to focus your energies on, can they do this job or not? Of course, taking into account, their obligation to accommodate people to the extent that they can, to the point of undue hardship, which we don't have to get into now, but it's a very high bar. It's very hard for employers to establish that they can't provide accommodation to someone. And there's going to be a really, really high threshold in terms of, what they're expected to do, just because it could cost a lot of money to, adjust a job or, bring in some equipment or technology to allow an employee to do that job. Like that's not going to be an excuse not to accommodate that person, right? But the one thing that I think, it's kind of a sad reality, but it really is important in the context of hiring. It's actually quite hard. It's probably the hardest situation to establish discrimination, because employers are going to have so much flexibility in terms of why not they've made the decision to hire someone, right? So even if something there is some kind of underlying discriminatory reason. If they don't really exhibit that at any point, there's no kind of like outward expression of that the applicant can see, like, okay, clearly there's something discriminatory going on here. If the employer afterwards, after an interview process, just says, we thought this other candidate had more relevant experience, recent experience, or this candidate, seemed like a better cultural fit or something, and they could give kind of like loose answers as to why they hired someone over someone else. And it's extremely difficult to establish discrimination in hiring, and that's kind of a situation where unions are effective, because when you're unionized, you can grieve essentially like your failure to be hired in a certain job, which is kind of its own legal process. You don't go to court, you don't go to human rights tribunal. Your union has its own lawyer that's already paid for through your union dues, and they'll fight that oftentimes, depending on the union, on your behalf. And that's where we see more of those cases kind of come up, simply because of the kind of cost benefit of pursuing something like that against like the risk of being successful and not putting a bunch of money into the file. Like, and that's something I remind my clients of, or prospective clients of, all the time. You might be correct from a legal perspective, you might be correct from like a human moral perspective, and a principled perspective, but it could be very costly to make that point, right? And you need to keep in mind that you might not recoup the money you put in certain situations. So I'm always very cognizant of that, because if I understand that people are very principled, like I myself am very principled, but I will also want to make sure at the end of the day, if they decide to retain my services and I feel that they're not going to, from a monetary perspective, necessarily come ahead, that they're fully aware of that, and they've essentially decided to kind of make that decision to proceed in any event. And that's kind of another good reason why these tribunals exist, these human rights tribunals, because it gives individuals an avenue to pursue things without having to worry about that cost benefit consideration.
Yeah, I just have a sort of a last sort of thing to add here. I think that what Andrew said is totally on point about cost benefit, about if it's worth it to pursue an employer if you haven't been hired and you think that it's based on discriminatory reasons. To be honest, Nita and Colleen's advice on this topic is way more useful for the average person than for and mine and Andrew's advice here, right? Because when you're out there looking for a job, you're not out there saying, okay, if I don't get this job, I'm gonna sue, right? That just doesn't happen. People don't have the time for that, right? I think it's Nita that said, if you're clearly being discriminated against in an interview, do you even want to work for this employer? We're lucky right now in Canada to be in a market where, there's a demand for workers, right? And especially in the interview process, it's so difficult to actually be able to prove discrimination, because unless you get a letter from that employer saying, we did not hire you because of your disability, right? Unless you get that, then you can't go inside someone's brain, right? And, obviously there's techniques to get inside someone's brain once you sue them, once you file a complaint, but it's so difficult to actually prove discrimination. So what's really good is sort of knowing what is discrimination, and feeling empowered to respond to discrimination or discriminatory conduct on the spot, right? And feeling comfortable about perhaps pivoting the conversation or asking why that question is being asked. I think that's the takeaway from sort of this part of the discussion we're having today, is not that you technically have a legal claim or you don't, and this is how much it's going to cost or whatever, which is, this is Andrew and my job. So like, yes, let's do it. but on the other hand, for most people, having a job, having an income, having a livelihood is more important. And in Canada, you're not going to get $1 million in a court case or in the tribunal. It's just not what you see on TV and like what the damages and monetary remedies are in the United States. It's just not, you know, even though the numbers are tending to go upwards these days, it's not going to be a sort of a windfall of a ton of money. So it's legal versus practical considerations are really important in the hiring process when you suspect discrimination.
I like that, legal versus practical. I like that. Yeah, and all of you had great points. Nita, yes, of course, of course.
So I want to talk about a broader topic though. So we're talking about the shift towards employee empowerment. And I know over the last couple of years, people have really been re-questioning their meaningfulness of work. And we're exchanging our time and our skills for money and for employment. So in that exchange, we have to remember that we also have power. All of the power does not lie with the employer. And so in that interview, if you're feeling nervous, you're feeling shy, you're thinking to yourself, maybe I shouldn't ask, you should know that you have power as the talent. And think about it this way. If we've got an employer who's so blatantly discriminatory in their interview process or in their hiring process, there's a strong likelihood that they're not able to retain good quality workers. They're suffering from turnover, and they've actually got a completely dysfunctional workplace, because that doesn't often happen in isolation, where someone's a fantastic manager, but they're discriminatory. Mm-hmm. So this may in fact be a telltale sign of a dysfunctional organization. So think about it that way, that these employers who are blatantly discriminatory, not accidentally discriminatory, blatantly discriminatory, themselves are often desperate for talent, and they don't have the power. You have the power, so don't feel shy. Don't feel nervous. Don't feel that you'll be kicked out of an interview. If you've got a question, just ask it, and just ask in simple terms like, how is this related to the job? Or what are you actually trying to get at? And feel powerful in that interview.
No, absolutely, absolutely. And that actually brings me to my next topic, which is equity, diversity, and inclusion. So the Ontario Human Rights Commission believes that the companies that are asking applicants to have what's called Canadian experience can result in discrimination. For those in attendance who are not familiar with Canadian experience, I'll say like a little bit of it, but I'm pretty sure our panelists can elaborate a little more on that. But from my research, the term Canadian experience is when an organization prefers candidates who have either lived in Canada long enough and simultaneously have worked long enough in Canada. And the reason why this could be considered discrimination, it's because it can be discriminatory towards immigrants, towards newcomers who have only lived, let's say, in Canada for 2 years and have only worked a year, but in their origin, in their birthplace, in their home country, they've worked 10 years in that same field. But in some organizations here, they don't see that as a qualification because they haven't worked the recommended or preferred hours or years in Canada. So my question to you then, to you all, could you explain a little more about what this term is and how it can be harmful to a newcomer and also a violation of human rights code? I can start with you, Colleen.
I've heard that term in such a very, very long time in regards to Canadian experience, because that's what myself as a talent acquisition specialist is not looking for. I'm looking for your experience regardless what country you live in. And one important thing that employers need to do is to remove the biases. And the biases start when it comes to the actual job description, the job ad, right? So removing some of those biases in regards to looking at the skills, looking at the qualification, looking at the education, looking at how it's equivalent, and looking at those skills that are cross-functional. I know there are, and I've heard situations where employers are looking for someone that has Canadian work experience, has worked in Canada for the minimum 4 or 5 years, where other employers are looking for, like I explained, the skills, they're looking for the equivalent of education. Do you have to remove those biases as an employer?
Mm-hmm. I agree, absolutely. Those can be very damaging for applicants and could also deter newcomers and immigrants from wanting to apply for the job, especially if it's a job that they know they can excel at. But seeing those dangerous and harmful words, it's not beneficial to them. Nita, may I?
I think Andrew may want to. Andrew, you were
Oh,
off
yes,
mute.
of course, Andrew. Yes, yes.
Oh, sure. The human rights legislation, one of the protected grounds, is place of origin, where you're from. And so kind of inherently in asking about Canadian experience, you're kind of sussing out where someone's from versus, are they, from Canada? Have they been in Canada, or is their experience outside of Canada? Therefore, inferring and, by necessity that they're from somewhere else, right? And then you're discriminating on that basis. So that's why it's problematic in most cases to ask about Canadian experience. We did discuss before, however, this idea of bona fide occupational requirements. So there are situations where it's necessary to have certain Canadian experience, so to speak. For instance, when for the like our profession as a lawyer, for example, to be called to the bar in Ontario and become a lawyer in Ontario, you have to, unless you kind of transition in some ways, but I'll leave that out for now. But in most cases, you have to article, which is essentially a 10-month paid internship where you work 7,000 million hours. But you have to article for an Ontario law firm for it to count as articling, right? And that's something that the Law Society has put in place. So if you as a law firm, selects an articling student that went to an Ontario school, and you're just doing what you have to do, right? And but by necessity, you're kind of trying to, or if you're hiring a lawyer as an associate, as a first-year associate, they have to have articled, and if they don't transition through other means, but which necessitates that they did have like Canadian or Ontario specific experience, so to speak. And I know that that's true of other professions and jobs as well, where there's kind of licensing requirements. So your beef as an employee or a prospective employee might be with that licensing body, but if you as the employer are just adhering to the requirements of a certain licensing institution, then it is what it is. But as Colleen mentioned, in most cases, it's just not going to be necessary. Like experience should be experience, and you should be assessing skill set, knowledge, and the things that are actually going to contribute to the job, irrespective of where that experience is. If it's comparable experience and it's somewhere else, it should make zero difference that it's somewhere else at the end of the day. So that's not going to come up in the majority of cases, certainly.
Mm-hmm. Mm-hmm.
I think that every single immigrant has a Canadian experience anecdote, every single one. And my parents came to Canada in 1990 and were applying for jobs to clean buildings, deliver pizza, and they had to have Canadian experience. So I'm going to out my parents, but what they did is they made up resumes, because who cares? The vacuum cleaner is the same in Poland as it is in Canada, right? So it's most, when I hear Canadian experience, I just think, this is nonsense. Most times it is complete nonsense. Now, Nita made a really good point before that. Most times, employers, they're not trying to be discriminatory. They're doing it unintentionally, which is still discrimination. But the better question to ask is, are you legally permitted to work in Canada? That is a completely valid question. That is a question employers can ask, and a worker, or if you're an individual who doesn't have a work permit or is otherwise not allowed to work in Canada, then yeah, that's okay if you don't get the job, right? oftentimes I think that's the question that employers are getting at, but they ask it in the wrong way. And again, like if you're asked that question, then this isn't a legal sort of area, but in my opinion, the good thing to do, the best thing to do is sort of pivot and say, well, listen, I have 10 years of experience in this field. Here are the my references that you can call or email, right? Sort of, bring the conversation to sort of, turn it away from Canadian experience to your actual real experience. And hopefully that will lead the conversation away from, your place of origin.
Mm-hmm. Absolutely.
I can contribute two things. So Paula, I agree with you that there's a standardized discriminatory practice happening. And I had a paper published on foreign trained professionals, and there's 3 areas of discrimination. One is around the foreign trained experience that gets discounted. Foreign trained education also gets discounted, as well as assumptions are being made about our language skills as immigrants. Now, I'm not an immigrant, but I say our language skills because we all at some point were immigrants, right? And so those assumptions are being made. And systemically, those decisions result in significant underemployment of immigrants. And the reason, the survey that I did actually took a look at employers. So I surveyed 99 employers and asked them about, what are the reasons around why you have these practices and who do you think has responsibility? And the truth is that these employers are actually shifting responsibility to other parties. They're saying the responsibility to prove that that education, that experience, and those language skills are transferable to my work environment lies with 2 primary people. That one primary group would be the individual applicant themselves. So when you're thinking about your previous work experience, write it in terms of what parts of that work experience are transferable regardless of geography. So maybe your transferable skills there are around, you developed a fantastic marketing plan. That marketing plan increased sales by 20%. So talk about it in terms of the pragmatic things that you have that transcend geography. And what are those competencies and how are they transferable? The other place that employers are looking for help is through the government. And so we can use things like the West, the worldwide, I think it's an education system where they actually qualify our education. So we go to that naive person who may, in fact, not recognize what our education is equivalent to. And we tell them, according to the Government of Canada, this is equivalent to a master's in HR. This is equivalent to something. So the employers are not looking because they're overwhelmed and because they don't know how to look. So they're saying instead, us as immigrants and us as government have a big role to present what parts of this can be interpreted. Mm-hmm. So a way out of that is for us to go ahead and there's a PLAR called the Prior Learning Assessment and Recognition. We could do a PLAR, we could get equivalency for our education. We can think about highly transferable skills regardless of what area we were in, and in the interview bring that up. Now, my heart did leap out of my chest a little bit, Paula, when you said that your parents made up their resume, some information that was Canadian. Please, please, please don't do that. From a legal standpoint, that means that even years down the road,
oh my God, I know,
you can be fired. So we have cases, even now we have cases where like the Walmart CFO, so it was Tohar, I think it was David Tohar, who got fired because he had said he completed a program that he didn't complete. He got 3 credits shy of that program, and he made it all the way up to the C-suite in Walmart. And then 10 years later was fired because he lied on his resume. So do not fudge your resume. Please don't make up an employer. Please don't make up references, because if you succeed and they realize that you lied on your resume, they can fire you, and they have cause to fire you. So please be careful about that.
Mm-hmm, mm-hmm.
And if you don't mind, I'm going to go a little bit beyond that in regards to the new world. When you submit your resume, it comes to what's called applicant tracking system. Applicant tracking systems are normally put together with keywords that an employer may be looking for a specific job. In case of engineers, it might pick up the fact that you're engineers, just as an example. So in regards to, like Nita said, write your resume in a way that that will present your skills that are transferable. However, it's going to be how you sell yourself in the interview. Because once again, it's going through a machine, which is applicant tracking system, a computer. And then when you meet with the recruiter, that's when you're going to be selling yourself, because they'll look at your resume and be like, I'm not sure. It doesn't really have the skills, but be prepared to, speak and talk to those skills that you have that are transferable during the interview process.
Mhm. Thank you. I will say though, that follows into my next question, which Paula brought up. It's just this this barrier that newcomers, that immigrants face when it comes to the hiring process, and that includes again, going back to the Canadian experience, how that could be harmful to newcomers. But leading into that, from a visible minority standpoint, then what kind of research should be done on an organization or a company to ensure that they are implementing equity, diversity, and inclusive policies in a work environment?
I'll start there, and I'm just going to give one example, because this is not my area of expertise. But one thing that I do, and what I did when I was looking for law firms to work at, I went on their website and looked at the current team. And, for me, it was really important to be able to have a female mentor at the law firm I was working at. And so I had to look at their website and see, is there someone who is 20 years ahead of me in their career who's working there, who is a woman, right? Or is there diversity in this team that I see here? Or is it, will I be the first woman that comes onto the team? That's the easiest. I mean, it's not always possible, because it depends what kind of job you're looking for or what kind of industry you're in. Not every, company has a profile of their and bios of all their team members. But, that's a really easy way to look at it is, go on their website, look at the team. Is this a team that actually practices what they preach if they're saying that they have a diverse workplace?
Right. And just to echo that, that's going to be a much easier exercise with a law firm, because they tend to post their lawyers and a picture and you can see everybody. But for larger organizations, consumer goods companies, or marketing or finance or whatever, you're not going to really be able to just do that on the website. But you could still, in essence, it's the same idea. You could still try to maybe do that on social media, like maybe on LinkedIn, or maybe on a website like Glassdoor, where you can see feedback of people that have had jobs at that company before, and what they have to say about it. I think it's also, you can make that assessment as well, even at the interview stage. Like if you have a panel interview process where maybe 3 people interview you and then another 3 people interview you, what is the landscape of the diversity of those panels? Is it just 6 white men, or is there all kinds of people from different backgrounds and with visible different ethnicities or things like that, or physical disabilities or something that could kind of inform what they're looking for as well. I think there's also nothing, like Nita's been saying, you as an applicant, you have every right to ask questions, right? And just simply ask, like, what kind of diversity policies do you have in place, and what are the kind of things that you do to ensure diversity in the workplace, and kind of a happy workplace. And another good point Nita made, and apparently full of great points today, is about turnover, right? Like I agree with her that in today's day and age, if it's a discriminatory workplace, or it doesn't even necessarily have to be discriminatory, right? Like you could have a baseline culture that's not discriminatory, but it's not overly inclusive, right? And you could have a culture that's very inclusive, and both of those technically aren't breaking any laws, but you prefer to work for a more inclusive workplace. I'd agree that they tend to have a lower turnover. So you could look at things like turnover. You could even, on LinkedIn is a great tool. I think people should use it to the extent that they have it. You can see you know, if you research a company, you could see, do you have any connections that work for that company? Or do you have any connections who have their own connections that work for that company? And reach out to those people directly and ask them, hey, like, you know, how do you find working there? What's the culture like? You know, do some legwork. And I think that that also kind of helps, you know, your ability to secure the job. You know, companies want to see that you're actively interested in working there. And when you go to an interview or you create a cover letter, and that in that process, you've identified that you've reached out to people and done your research about the job and know that that's a place that you're interested in working in, that's going to be, you know, music to the ears of employers, because they're looking for people that want to be there, especially if it's a competitive landscape. So there's a lot of things that you can kind of do at the front end to get a sense of what's going on, and you know, an idea of if it's a truly inclusive and diverse workplace.
Can I step in there, could I do?
Of course, of course.
Great. So I love the idea about thinking about who currently works for the organization. But in the last couple of years, I'm on a governance professionals board as well. And in the last couple of years, the conversation that's been happening in the top executive teams has been around doing better. So there's been a big recognition that came, and some of it was from the political social movement of the BLM advocacy, but there was other movements that were going on as well, our dependency on immigrants, but it's this big conversation about doing better. And although they might not currently have diverse hires, there are, most of the organizations that I've been interacting with are trying to do better. And so asking them perhaps about what their diversity goals are in the future and what actions they're taking can help. We've also seen a shift with some of the regulatory bodies that are now suggesting that you have to have a minimum of one visible minority and one gender minority on your board of directors. And to meet those targets, I'm going to those board of directors meetings and the CEO and executive meetings, and they're asking me, where are our diverse applicants? And they're looking for them. So let's not self-select out of the process. Let's go in there, even if we see that it's a traditionally homogenous board, like a traditionally, you know, blank board or one type of a board, and move in, or employee group, and move in there and say, you know what, I could be part of the solution here. And I'm saying this as a visible minority woman who went through this myself. You know, there were times where I joined teams where it wasn't diverse, but it wasn't because of an intentional lack of inclusion. It was systemic problems that led to them not being diverse. They weren't going and recruiting at the right places. They didn't have the right language in their recruitment ads. And when I joined on, I got to be part of the solution. And that always helps too.
Amazing, amazing. On the same topic, we actually have a question, or one more so is a comment referring to the discussion, and then the other one is a question. The comment is, even immigrants have years of experience in some field with transferable skills. However, the employers do not care. They just require the Canadian experience instead of giving them a chance. This is something we should fight against. I don't know about you guys, but I definitely agree with that statement. Mm-hmm.
And that's where sort of, you know, the legal process comes in, right? In Canada, in the vast majority of forums, legal forums, the process is what we call adversarial, meaning somebody who feels like they've been wronged, that that somebody else has broken a law and they've suffered some sort of damage, some sort of injury. You know, that person has the responsibility then to go and pursue their legal claim. And we won't get into all the different ways you can do that. We'll talk about, you know, if your legal claim is, you know, a human rights in nature, then usually what you'll do is go to the Human Rights Commission or Human Rights Tribunal, depending on your province or territory, and you start a claim. So yes, that is one way to fight, right? That is one way to, you know, try to hold that organization, that employer accountable, is to go through the legal process. And there are so many different advantages and disadvantages, one thing that I like to tell my clients or ask my clients at the beginning when I first meet them is, what do you want, right? Do you want to expose this organization? Do you want the media to get on board here? Do you want lost wages? Do you want to recover the wages you would have earned? What do you want? Do you want to be sort of personally vindicated? And all those questions, depending on what you want, pursuing in a legal forum, may or may not be the right answer for you. So the fight against discrimination can be fought in the legal form. It can be in the form of public opinion, right? There's lots of different ways to hold organizations and employers accountable. I think probably Colleen and Nita are better, are going to be better positioned to talk about, what ways you can fight back or fight for, for yourself and for your community other than, the legal process.
Yeah, and just the last comment that I have is in regards to DEI. Since George Floyd incident, I noticed that a lot of organizations now have a DEI statement. Doesn't mean that necessarily that because they have a statement that they're actually following through. Like Nita says, it's going to take some time. They're bringing in now professionals to train. In regards to when it comes to racial sensitivity, they're bringing professionals in regards to look at recruitment processes, removing, like I will always speak about the biases. And it's so true. There are a lot of new immigrants, there are a lot of different diversity groups that like to apply for at a certain organization, but because the job out of the job description, they feel that they don't have the qualifications that meets, because we look always sometimes for the highest education or the highest type of skills. So it's a work in process. I noticed that it's no longer talking about what's the cultural fit. It's more or less, how many people do we have that represent those that may be looking at our organizations? I know of people that have, been up for a fantastic job and gone look to the website and have not seen anybody that could somewhat represent what they look like and have not gone forward with that job. So employers are doing their best right now to bring in the training, get the help that they need in terms of, making workplace more diverse and inclusive.
Thank you so much for all of your points. I really do appreciate it. It's very, very informative. The next question we have here, it actually goes back to a previous discussion we were having, and the question is about the question of having children or not. Can we really respond to the recruiter and say what is the relation with children and the job? I guess this was mentioned before, where you are able to question, but I would like to still get your inputs as well, if anyone would like to answer that.
Absolutely. Sorry.
Sorry. No, go ahead. That's fine. Totally fine.
Absolutely. That has nothing to do with how you're going to perform at the job. You have every right to ask, how that correlate with your day-to-day activities and bluntly, why is this important? And that is the same in regards to whether or not you attend a certain type of church, whether or not you're part of a certain type of association. Mm-hmm. Absolutely.
Right. Agreed entirely. I mean, there's just, I think that the important connection to make is the underlying, the underlying protected ground, so to speak, is not what's relevant, right? Like if you have a certain medical issue, for example, it's totally irrelevant to the employer what your medical issue is. What's relevant to the employer is, do they have to provide accommodation? Is the job structured a certain way? And do they need to provide some form of accommodation to account for the fact that you have a disability, regardless of what it is? Does that disability mean that you have certain restrictions and certain limitations that they have to consider in ensuring that you can do your job, right, as someone with a disability? And those are the important questions, right? It's the outcome that's important. The underlying reasons aren't important. So whether or not you have kids, it could not be less relevant to anything, right? What could be relevant is, the company's open for a certain period of time, you're being hired for this certain time slot, and maybe the employer's concern in that question is, okay, are you able to work those hours? Or are you going to have to take time off because you have kids for childcare reasons or whatever? Like, but again, they don't need to know whether you have kids for that reason. They just need to simply know, can you work those hours, right? Like, that's it. And that should be the question. Like, here are the hours of work. Are you able to work those hours of work, right? Like, this is where we're open, right? So I agreed. Like, there's such few instances where an employer is justified in asking any question related to, like, what is your religion? What is, your family status in terms of having kids or a spouse or your sexual orientation, or if you have a disability. Employers should not be concerned about that at all. They should simply be concerned about, if anything, are there limitations and restrictions that have to be accommodated for, and consider how they can go about doing that. That's all that matters. So Colleen, I do completely agree with what you just said.
Amazing. Thank you. Thank you so much. Nita, I have a question here for you. It says, thank you all for the information and resources. The prior learning assessment and recognition service that Nita mentioned, does it have a cost for professionals that would want to use it?
So I'm just writing up a response. I'm not sure whether that one's got a cost because it is centralized by the Ministry of Training and colleges, I believe it is. And then just the educational institutes are the ones who implement it. But I'll also share a link with other international assessment centers, some of which are not for cause. So the one that I generally promote is the World Educational Services, because that's really good. But there's 5 that are going to be part of that link that I'll send out to Maria and the rest of the team.
Amazing. I don't know about you guys, but I am being flooded with so much information that you are providing, and I absolutely appreciate and love it. I'm definitely taking away a lot of information from this panel discussion. The next thing I would like to, so diverting away from equity, diversity, and inclusion, I would like to now discuss employment contracts. Some people, first, actually, before I get into my questions, we have another question pertaining to that. Let me just pull it up very quickly here. Oh, okay, so it says, during a probation period, how much notice does an employee have to give when resigning? Does the employer have the right to terminate a contract on the spot without any notice? Andrew, may I ask that you take this one?
Sure. Every province is different, right? So it matters where you're from. But in Ontario, for instance, our employment standards legislation has pretty much said that, if you're terminated during the first 3 months of your employment, you're not owed any notice or pay as a result, right? But that's kind of like an oversimplification of that situation. For starters, an employer is going to have a lot of leeway during those first 3 months to make an assessment as to whether you're a good fit and they want you to be there or qualified or whatever. But that being said, that has to be done in good faith to some degree. And, beyond that, even though you might not be, entitled to your minimum termination pay under employment standards legislation, that doesn't necessarily mean that you're not entitled to something called your common law severance. And simply put, essentially, I won't get into it too much, but there's an idea that there's this full severance entitlement, which we call your common law severance, and then there's your minimum severance entitlement, which is outlined in legislation in each province and federally. And the default idea is that you'd be entitled to your full severance entitlement unless there's something in your contract that tries to limit you to the minimum. So if you had a contract that limited you to the minimum, then if you were fired in the first 3 months, you'd likely get nothing. But if you didn't have something in your contract that limited you to just your minimum entitlements, even if you were fired in the first 3 months, you'd still be entitled to severance pay. And especially in a situation where you're induced to leave another employment, right? Like if you had a job for 10 years and you were poached to come over to a new company and they let you go in the first month or 2 months, you could have an argument that those years of service at your previous job should be accounted for in assessing how much severance you get, which could, drastically improve your entitlements, right? So it's going to be very situational and specific to the facts of your, particular case. And, that will kind of segue nicely into our conversation about contracts in a minute. But, I think what's really important is, always like our one thing about our firm that we do very well is we try to be a source of information for people. So we have a radio show and a TV show called the Employment Law Show, and it's actually just a call-in show where people can call in and say, hey, this is happening to me at work, or that happened to me the other day, and ask, briefly about their entitlements and their situation. And the best thing you could possibly do if something like that comes up and you're unsure is just speak to a legal professional or an employment law or human resources professional about your potential rights. Usually there won't be a cost associated with a consultation, and if there is, it's going to be minimal. And definitely, there's people that have paid me $300 or $400 for a consultation to discover that they're owed tens of thousands of dollars, right? Or otherwise they would have never known that. And it's just a small, I'm not saying that's not a lot of money to some people, but at the end of the day, if you can, or if you can get a free consultation, which will often be the case, you're best off just to ask and find out. And even if the answer you get is no, everything the employer did was above board and totally appropriate in the circumstances, at least you have that peace of mind. But for the individual who asked this question, just because you're let go in that initial 3-month or probationary period doesn't mean you're not owed severance. And also, sometimes employers try to mandate probationary periods that are longer than 3 months. So if they say if there's a 6-month probationary period and you're let go after month 4, then you're owed something at minimum, right? So it'll all come down to the specific circumstances.
Of course.
Yeah. Oh, go ahead, Nita.
Yeah, can I push on that question? So what about those employers that are manipulating the system and they bring people on in temporary roles or in limited roles and say, okay, I'll bring you on for 6 months, but they do this for 1, 2, 3, 4, 5, 6 cycles. And they keep putting you back on this probationary period. Is that perceived to be continued employment? Or is that,
Right.
7 cycles potentially? I know someone who's been with IBM for 11 years on 11 different 1-year cycles, right? Is
So,
that considered to be continued employment?
very excellent question. Very excellent question. So there's 2 parts to that question, essentially. One is in employment legislation, when you're discussing the kind of the probationary period for the purpose of the legislation as it's outlined, it's always going to start with the start date of your job, not the start date of the new contract, right? So the same thing could apply if you have a job for 8 years and you're promoted to a new job, let's just say, and they say, oh, you have a 3-month probationary period in this new job. That means nothing. You could get let go, the employer might be setting the tone that, look, this is a new job. We're going to be looking at this carefully to see if it's a good fit, and they could let you go, totally fine, but they owe you severance based on your whole length of service. They can't just say, oh, there's this 3-month probationary period. Secondly, our court system, across the country, regardless of province, and I'm called to the bar in Ontario and Alberta, and soon to actually be BC, and we have an office in BC, but they'll interpret a series of what you've brought up is something called a fixed term contract, which is a contract where there's a set duration. Most contracts don't have a set duration. More often than not, they just say you're hired, and it'll outline that you can resign under these terms and we can fire you under those terms, but there's no set end date. So as soon as an employer in a situation where there is an end date starts to then tack them on one after another, the court will interpret that as a continuous employment, especially if there's 3 or more contracts. Then it's almost like a no-brainer that they're going to say that, regardless of the fact that your fourth contract is set to end in 2 months. We don't care about that. We're going to consider you a 2-year employee or a 4-year employee for the purpose of your severance. And the last point I'll make, which is quite interesting, is a fixed term contract can be a very, very interesting situation, because if, for example, let's say you're an employer and you hire someone right off the bat, you say you have a 2-year contract and there's a start date and an end date, and that's your contract. If there's no enforceable terms limiting your severance, then you would have an extremely strong argument to say that you're owed the balance of the contract, right? So I had started a claim for an individual who had 2 years of service, but he had a 5-year fixed term contract. And, you know, in the ordinary course, an individual with 2 years of service could be owed anywhere between, 2 and 6 months of severance. So I won't get into all the reasons why, but because this person had a 5-year fixed term contract and there were 3 years left on the contract, we argued you owe him 3 years of pay, right? And that's a very strong and palatable argument. So that's those are situations where short service people can get exceptionally high payouts. So it's something to look out for as well.
So I think that there's something really important about employment contracts that I find employers have a hard time understanding. And so I take the employment part out of it. And I say, you're signing up for a cell phone plan, and you sign up with the carrier and you sign a contract, and the contract says, Paula, you can terminate this contract. You can choose to go to a different carrier, but you have to give us 1 month's notice. It's not new. It's not something exceptional in the world of employment to give notice when you want out, right? An employee can choose to leave, an employer can choose to leave, but both parties have obligations to provide notice. The reason why in employment, those periods of notice are usually longer than in a commercial contract is because employment is something different, right? Employment is not, getting a car lease or getting a phone. It really is to do with your identity, with your self-worth, right? Employment is usually the thing that people spend the most time on during their day and their lives, right? So there's a special kind of consideration about the notice that you give to the other party in an employment relationship when you want out. And the period of notice that an employer will give an employee is going to be longer than when an employee wants to resign. So I think the question talked about resignation and how much resignation notice do you have to give to your employer during a probationary period? I would reframe that question to say, how much time in general do I have to give the employer, right? Whether it's within the first 3 months or 10 years later. As an employee, the first thing you go to is your written contract. Anything that you ever signed or agreed to in writing might have a rule there, might have a section. If you want to resign, you must give 2 weeks of resignation notice, or you must give 4 weeks. So if that's the case, then that's your starting point. And if there's nothing in your written contract, or if you don't have a written contract, the next question to ask yourself is, in these circumstances, what's reasonable? Am I in the middle of a really big deal? Am I like the project manager for this deal? And if I quit today, it's all going to fall apart, right? That's probably unreasonable. You probably have to give a few more, a couple weeks at least, maybe a few more. But maybe you're in a position where you know that there's already 5 people who can easily replace you, right? When you're resigning, whether it's in a probationary period or not, look at your contract and then look at, what is a reasonable amount of time for my employer to go find someone to replace me and train. And if you're still unsure, it's a good idea to go see a lawyer.
Absolutely, absolutely. Paula, you mentioned a commercial contract. I was just wondering if you could briefly just define what that is and how that differentiates between, I think you said,
Yeah.
yeah.
So a commercial contract is a contract between essentially two companies, right? Yeah, usually it's two companies or like a contractor and a company that's closer to a commercial contract. But an employment contract is different than two companies coming together, because two companies usually coming together into a contract, the power balance, like the balance of power is similar. Well, in theory, is similar, is more or less equal. In an employment contract, not in every single case, but in most cases, there is a big power imbalance. Usually the employer has a lot more power in that situation. The employer is the one with the job, with the money in the bank to pay you with, right? And the employee is usually the one who needs to find a job to pay their bills. That's an oversimplification of the concept, but generally speaking, employment contracts have just a bigger disparity in the power. And so our courts in Canada have made decisions and made rules on employment contracts to, especially at the end of the employment relationship, to sort of make sure that that power imbalance is at least somewhat rectified, and the employee is treated fairly in consideration of this power imbalance.
Okay, thank you. Thank you so much, Paula, for clarifying that. I heard of it and I was like, wait, it sounds familiar, but let me hear from you the more definitive definition of it. On the same topic of contracts, so my question to, I guess, primarily to both you, Paula, and Andrew is, so let's say the interview goes well. No human rights were violated and the employer is feeling good about the potential new employee. The employer presents a contract, in this case, I guess the employment contract. The contract and agreements can be, what I find is that contracts and agreements can be very, very intense, can be detailed. It can, in some cases, be hard to decipher right away. What should the candidate watch out for before signing a contract? And then my follow-up question would be, is, what would be the importance of, or when, how could I word this? How could an employment lawyer play a role in signing a contract?
Paula, do you want to start, or?
I've done a lot of talking. I feel like you should take this one.
Okay, well, good questions. I mean, the first thing that I'd like to kind of preface all of this with is, although it might seem counterintuitive, in an ideal world as an employee, you don't want an employment contract, okay? So sometimes people call me and they're like, oh, I didn't get a contract. I've been asking for a contract. Where's my contract? You actually don't want a contract, and a written contract, more specifically. And the reason for that is pretty simple. It's that contracts are formed without necessarily something being, pinned down to writing, okay? And what I mean by that is sometimes just by virtue of your conduct or activity happening over time, that becomes the term of your employment. So like a prime time example is if an employer hires you and, they say verbally, we're gonna pay you, whatever, $30 an hour, let's just say. There's nothing in writing about that, but that's what you've been told. Now you've had this job for 8 months, and during this 8-month period, you've been paid $30 an hour. And just like the employer said that they would do, it hasn't been in writing, but that's what they said. If the employer now tries to reduce your pay and say, well, it wasn't in writing, we never agreed to that in writing, so now we're paying you $20 an hour, no, that doesn't fly, because by virtue of them just paying you for that period of time, that becomes, your reasonable expectation. That becomes the term of your employment. And the things that you're looking for as an employee, more than anything, are, what job am I doing and what is my compensation for doing that job? So just by doing a certain job over time, you've established that you have a certain job. So if they try to change that job, you have legal recourse to say, I don't have to accept these changes. I'm going to treat this like I'm a termination and pursue a severance. Or, my compensation has been X over time. And if the employer tries to reduce it, you have a claim to say, no, I don't accept that reduction. I'm going to pursue monetary entitlement against the employer. A written contract, it will kind of, formalize those things, your duties and compensation, but all the other terms are going to be favorable to the employer. It's going to give them the opportunity to say, we can change your work location, we can change your hours. Like, even though you work 9 to 5 for 2 years, we have the right to change your hours of work at any time we want. We can change your duties. We can change your commission plan or your incentive payments. And we can put you on a temporary layoff. We can fire you with, minimum notice. These things are always going to be favorable to an employer. So number one point, more than anything, is although it might seem counterintuitive, as an employee, you do not want a written contract. If you're, if you need to sign a written contract to get the job, which happens in a huge percentage of cases, the main things you want to look out for are, one, any terms that give the employer discretion to make changes, like I just discussed, changes to your hours, your work location, your duties, your benefits plan, your compensation, anything that provides discretion, because if they didn't have that discretion, you would have a claim against the employer for making detrimental changes that you did not agree to. As soon as they say we have the discretion, that eviscerates most cases, and it's just tough luck, right? So that's number one. Number two is, termination provisions are humongous. Like, if there's any language that tries to limit your severance, that's really, really important, because that can make the difference of being entitled to 8 weeks pay or 8 months pay, which is humongous at really any salary. Even if you make $45K a year, to get an 8-month severance package versus 8 weeks, that's whatever it is, $25,000 of difference. So you want to take a look at that. You want to look at things that we call restrictive covenants. So things like non-compete agreements, non-solicitation agreements, anything that tries to limit your activity after the end of your employment. So a lot of contracts will say, for 12 months after your employment, you can't work for any competitor in Ontario, that is engaged in the same business, or you can't solicit any of your customers that you worked with at this company. So you got to keep that in mind, because if the job doesn't work out as you thought and you're let go, those types of provisions could theoretically hinder your ability to get a new job quite significantly. Another big one is temporary layoff provisions. If you see in a contract that we can put you on a temporary layoff, that's another huge one, because temporary layoffs can last months, and depending on the province. In Ontario right now, there's a new legislation that was passed during the pandemic, which has resulted in people that have been on a layoff for almost 2 years now without pay, which is just like mind-boggling. And if that employer has a provision in the contract that says, look, we can put you on a temporary layoff, there's really nothing you could do about it, where otherwise you could go to a lawyer and say, I don't accept this layoff and I'm going to pursue my severance and just treat this like a termination. Now, with respect to what you can do about it, you can see an employment lawyer, and they can, like Paula or myself, and we can run you through all of these things. We can flag all of these issues. And then really it's just up to you to negotiate, the terms of the contract, right? So, it depends how much leverage you have. It depends how much they need you, how much you need them, how much you want that specific job. And I can there's some people that want a job so badly, I could tell them 15 things that's negative about their contract. They're like, I don't care, I'm going to sign this. Or there's people that have, a secure job and they're being, induced to leave that job for somewhere else. They're going to be less, concerned about the new employment, and it has to be very, the right fit for them to take that job. So really it's just a negotiation, and really beyond anything that's kind of legal, because it's just up to you to whether or not you want to push back on certain things or not. And we can help you frame that to your employer in ways that, you know, are going to be maybe more digestible and doesn't look like you're just trying to butt heads. There's also a lot of situations where even though something is written in a contract, because it's not written correctly, we could still get around it, right? You don't want to necessarily rely on that. It's better if it's not in there at all, but that is also an option available to people. So hopefully that was helpful for those concerned about employment agreements.
Absolutely. I wrote some stuff down too, actually.
Um,
Paula, yes.
I think that, you know, one thing that Andrew said that is really important is, you know, what you stressed, Andrew, at the beginning is, you know, employees, it's actually better to not have a contract. Everyone has to remember that, like, once you're employed, you have a contract. It's just either verbal or written, or perhaps a combination of the two. A verbal contract is just as enforceable and valid as a written one. It's just, you know, sometimes a bit harder to agree after the fact what you agreed on back 10 years ago or 5 years ago, because if your contract is verbal, everyone can have a little bit of a different recollection of what happened that day you shook hands, right? And so you have to remember that a contract is when different parties come together and exchange something of value, right? So in employment, an employer is exchanging compensation for your services, right? For your talent, for your time, for your work. So that's what's being exchanged in that situation. And you don't need a written contract for this employment relationship to be valid under the law. And so when you do have an employment contract, it is always going to be written in 99.9% of the cases, going to be written by the employer. So you best believe that it is going to be favorable for the employer. Many cases, you don't have a ton of leverage to change parts of it. I agree with Andrew about the parts of the contract that you need to really look out for. And I think they can be summarized as what happens at the end of the employment. You've got a written contract, look through it, read the whole thing, and especially focus on how can my employer change my employment, finish my employment, and can they restrict me after my employment? Because nobody goes into an employment relationship thinking this is going to end really badly one day. But, you know, everyone has high hopes, perhaps, you know, idealistic about where your career will go, how your relationships will be. And then one day you get this really awful boss. And, you know, you have to then fight about your entitlements at the end of the employment relationship. So those are, when you have a written contract, those are super important. Even though it's not something on your mind, top of mind when you're going in, it is the most important thing when you're going out.
Absolutely. Thank you. Thank you. I think it is very important to keep these things in mind, how an employer can change the contract and what can happen to you after you quit. A lot of people think, oh, once I quit, done. And that's not always the case. Before we go, we just have one final question from our audience. And it says here, I think I got to read it, and I think it's more along the lines of discrimination. Shaking hands is typically one of the first in-person interactions the employer experiences with an interviewer. Is more to seal the deal, I guess. What if a candidate doesn't shake hands because their culture might place certain restrictions on handshakes? How does the candidate make sure that they are not being discriminated against in a job interview for refusing to shake hands? That's a great question, because you're comparing culture, like Western culture, to a culture that does not, you know, prefer physical contact as such. I guess I can ask Colleen.
I don't think you have to worry about that anymore because of COVID. In terms of everybody's, you know, honestly no longer shaking hands. Everybody is, you know, sort of doing like a up in the air kind of thing, elbow, fist. But I do understand, and I understand where this question is coming from, because with different cultures, it's sometimes with eye contact. Some of the things we're taught as HR professionals, especially in recruitment, is make sure there's eye contact, make sure there's a firm hand grip. That's okay. I mean, if that becomes the case where we get over COVID, and we do go back to the handshake, I think there's absolutely nothing wrong letting the employer know that due to your religious belief that in your culture you do not shake hands. I don't think there's anything wrong with being very transparent. Sometimes the receiver may not receive it as well, but I don't think there's anything wrong. But based on what we're seeing in the world now, I don't think that's going to ever happen again with handshaking. Not sure what you think. Your take is on that.
I agree.
I can
also
just
think,
go ahead, Andrew.
I was just going to say very, very briefly. I think that would also be a very telling example of discrimination in the hiring process, because if you're at the point where you're shaking hands, that means they've offered you the job and they want you to accept the job, right? Like you're done. And if you express for religious or cultural reasons that that's not something that you're comfortable with doing, and you politely decline, and all of a sudden the offer is rescinded, I mean, that's going to be very kind of overt, and you'd have great grounds to start a claim or have a human rights complaint against that employer, because how is it that they've offered you this job, and then the only thing that happened after that point is you rejected this handshake, and now all of a sudden the job's rescinded. So I mean, an employer would be very silly to do anything to retaliate against like a refused handshake for maybe religious reasons. And I would certainly just be forward about your inability or uncomfortability to do that.
Absolutely.
Yeah, if I can add into that too, I think what's unique about Canada is we are truly a mosaic. And whether that means it's a religious right or a personal right, we see it all the time. And I'm telling you, with 21 years of teaching experience behind me, that at the university level, I've seen, a big fluid movement towards how people dress, what they're acceptable with, and what they're willing to say they're willing to do. So not even saying that it's a religious reason why you don't want to shake hands. If you just don't want to shake hands, legitimately just say, I'm just not the type of person who shakes hands. And just that should be, you don't need a reason anymore. There's a greater tolerance for our own idiosyncrasies, like our own uniqueness. I have certain things that I'm not comfortable doing, and sometimes just saying I'm not comfortable doing this is always a great idea. And when it comes to personal touch, when it comes to how close you stand to someone, just literally put it out there. And that is a very common social cue that you could signal.
Absolutely. And with 6 feet distancing, I don't think we, like Colleen said, that's something we won't have to worry about now with COVID, unfortunately. Paula, Andrew, Colleen, and Nita, thank you. Thank you so much. This has been a very, very, very informative and engaging conference. I'd like to thank you all in attendance for being a part of this panel discussion with your questions, and also tuning in and listening. I hope I was able to take away a lot of information from this panel discussion, and I really hope that everyone in attendance was able to do the same as well. We're able to take away information and facts and about your rights during the recruitment process. I'd also like to quickly inform everyone that and to remind everyone that this is an ongoing series on employment equity and rights. Our next panel discussion will be on Thursday, February 17th. So keep an eye out for the announcement on Connect to Canada's Facebook and LinkedIn page. If any of you would also like to personally reach out to any one of our panelists, I will add their information, their emails, into the chat bubble for everyone to see. Once again, thank you so much to our future panelists, and thank you all for joining us today. See you next time on Know Your Employment Rights. Take care. Thank you, everyone.
Hey, thanks everyone for the opportunity. Have a good day.
Bye, everybody.